Good morning or afternoon, as the case may be, and welcome. We're glad to have you at this IMGL Masterclass for the Tribal Gaming Series on ICE 365. And we'd like to thank the IMGL for sponsoring this event and for all the assistance in setting it up. We have a really terrific panel today for a one-stop analysis on what's trending at the intersection of sports betting and tribal gaming. Some 2.5 years after the United States Supreme Court struck down the federal ban on sports wagering, we have about 24 states plus at this point that have some form of legal regulated sports betting up and running, and nearly 3/4 of the states in the US have introduced legislation. More tribes are considering getting in on the act as well. And for American Indian tribal governments who own or potentially operate casinos, a tribal state compact is required under the Indian Gaming Regulatory Act, the federal law passed in 1988 that regulates tribal gaming. Today, we're going to look at some of the issues in particular surrounding the negotiation or implementation of tribal state compacts and how those intersect with issues that are current and dynamic in the areas related to sports wagering and the introduction of that in the US. We have a great panel. It's highly experienced. I'd like to introduce first and foremost Heidi McNeil-Stoudemire, who's a partner at Snell and Wilmer LLP in the US, where she practices in Native American law, gaming law, and business litigation. Kevin Quigley, also first and foremost, who is Indian Affairs and Gaming Business Counsel at Foley and Quigley PLC in the USA, where he also practices in these areas. Catherine Rand, third for first and foremost, who's professor of law and co-director of the Institute for the Study of Tribal Gaming Law and Policy at the University of North Dakota, and also a vice president of educator members of the IMGL. And my name is Steve Light, and I'm a professor of political science and public administration. And with Catherine, I am the co-director of the Institute for the Study of Tribal Gaming Law and Policy at the University of North Dakota. Well, with that introduction, let's get into it and let's have a conversation about what's going on with our experts. So one of the first questions might be why we would want to or need to be talking about issues related to compacts at all. Catherine, since some in our audience might be experts in this particular area and others might be dealing with issues related to the legalization of sports wagering for the first time, or be new to issues related to tribal governments in particular, why are we talking about tribal state compacts at all today?
Sure. Thanks, Steve. So, as you mentioned, sports wagering is a Class 3 game under the Indian Gaming Regulatory Act. Although sports wagering isn't mentioned in the statute itself, under the regulations of the National Indian Gaming Commission, it is specified as a Class 3 game. That means it has to be operated by an Indian tribe on Indian lands in a state that permits that kind of gaming and under the auspices of a tribal state compact. So before a tribe can operate a sports book, it has to be authorized by the tribal state compact. And in some circumstances, it may require the state to formally legalize sports betting, at least for the tribe.
That's a really informative initial answer for us, Catherine. And actually, I'd like to follow up with you for just a second as we're setting the stage for our conversation with our practitioners. So as an academic, you look at these kinds of issues from the 30,000-foot level. What would you expect from the overview perspective might be some of the kinds of key topics in compact negotiations between a tribe and a state if sports betting might be on the table?
Sure. So a couple of things that are sort of obvious from the get-go, but are very important. First of all, that the compact will have to include sports betting as an authorized game. Now, for some tribes, their compacts already have a broad authorization, for example, of all Class 3 games. So their compacts are ready to go in terms of the specific games permitted. Other states have entered into compacts with tribes that specify particular games that are permitted. So instead of saying all class 3 games, they might specify a list of particular class 3 games that are authorized by the compact. If sports betting is on that list, again, good to go. But if it's not, then the compact will need to be amended to specifically authorize sports betting. And in that case, where the tribe is in a situation that offering a sports book requires amendment of the tribal state compact, we can expect other issues to be part of those negotiations. So we can expect the circumstances under how the game is played. And the hot issue, which I'm sure that we'll talk about today, is whether the tribe can accept mobile wagers. And if the tribe can accept mobile wagers, where? But other issues related to adding sports betting to a compact would typically raise the idea of revenue sharing. So either increasing the revenue sharing amounts already paid to the state or bringing it into the negotiations for the first time. And one thing that both the tribes and the states should be aware of is that as they're thinking about the possibility of revenue sharing related to sports books, they should be conscious of the fact that sports books don't generate a lot of gaming revenue. They're very popular and they attract customers and encourage non-gaming spend, but these are not necessarily the most profitable games in a casino.
Wow, so it sounds like there's really a range of issues to deal with and a range of issues that might be on the table for negotiation, not to mention that we would have different states, different tribes, and different jurisdictional issues as well. So let's get into that. Thanks, Catherine, for setting the stage for us. I'll turn this over to both Heidi and Kevin. You both have extensive practical experience as practitioners with compact issues that have arisen in various jurisdictions, including the kinds of issues that Catherine has mentioned, whether it ranges from the permitted scope of gaming or exclusivity or revenue sharing, or perhaps mobile wagering, et cetera. So let's talk about a few of those issues initially and get them out on the table with any specific examples you'd like to offer, and then we can take a little bit deeper dive. So I'll turn it over. Heidi, would you like to start for us?
Sure. In terms of what Catherine just said about the compacts needing amendments in certain instances to permit sports betting, I can happily report that as of Monday night, April 12th, the Arizona State Legislature approved an event wagering bill, which essentially will legalize sports betting both on the reservation and off the reservation in the state of Arizona. Hand in hand with that, for the last almost 5 years, the tribes and the state of Arizona have been negotiating for a compact amendment that would not only permit sports wagering, but also numerous other terms to amend the existing compacts that we've had in place since 2003. And at present, we have 19 tribes and the governor that are going to be signing those compact amendments this week and ready for submission to the Office of Indian Gaming for approval. So it's extremely historic event, very momentous. We are very, very happy here in the state of Arizona, both the tribes and the state, for working so hard for so many years to finally come to an agreement that will benefit everybody in the entire state of Arizona. So I'm very happy to report that. Just a couple points on the legislation that was passed. It will it's going to authorize up to 10 licenses to the tribes and up to 10 licenses to professional sports franchises, such as the Arizona Cardinals and the NFL, professional golf, baseball, hockey, NASCAR, and there's very specific limitations there will be in terms of how the sports betting will be conducted and where. At present, there's no details yet as to how the licenses will be awarded, how much the license fees will be. That's going to be part of the rulemaking process. The primary regulator is going to be the Arizona Department of Gaming. And so that rulemaking process, as soon as the governor signs the bill, which will happen this week, the rulemaking process will start. And then we will have more details about how the actual process is going to move forward in terms of how the licenses will be issued and all the other details. So a lot more work, a lot of work has been done, but a lot more work remains to actually get things up and running. But I think the goal is to actually have sports betting available by this fall, before the professional football season starts. So that's kind of an overview of what's happened here in Arizona.
So Heidi, congratulations to all who were involved in that. That's a really exciting development. Could I follow up with you on one of the key elements that you described, and to the extent possible, maybe you could tell us a little bit about what might be the implications of it or lessons learned, and that is the involvement of the professional sports franchises. So that is really sort of headline news that we have compact renegotiation, that this is tribal gaming, and that major states and really globally are a part of that. Are there any, were there wrinkles to that? Was that something that we could expect to see some lessons learned? Is this the first kind of agreement of its kind? Those kinds of questions might be of interest to our viewers.
Well, the professional franchises, that is not part of the compact amendments. The compact itself has what's called a poison pill, and the tribes have exclusivity to conduct Class 3 gaming in the state of Arizona. And as part of the compact amendment negotiations, the tribes still have exclusivity. There is simply going to be a carve out for these limited licenses that are going to be granted off the reservation. But the tribes have retained their exclusivity, and in fact, under the 2003 compacts, the tribes have been paying a certain amount of revenue sharing to the state, up to 8%. Under the new compact amendments, the revenue sharing is going to stay in place for the most part, but only certain tribes are going to pay revenue sharing, and other tribes will be paying a much lesser amount in terms of revenue sharing. So the tribes, from the point of view of the professional franchises being involved, we had to be very careful in these negotiations to assure that the tribes retain their exclusivity, because that is a very important part of the Indian Gaming Regulatory Act, that if there is going to be revenue sharing, that is not deemed to be a tax on the tribes. And so that was very, very carefully negotiated, with the tribes being involved in terms of what made the most sense for their perspective, and how sports betting would work for off the reservation. In addition to sports betting, the other carve out in the legislation is that daily fantasy sports contests will be permitted off the reservation, as well as Keno kiosks at only certain limited fraternal organizations like the VFWs, local VFWs. Certain of them will be allowed to get licenses to conduct Keno. So it's very momentous, but it was very, very carefully drafted with the tribes very much in mind for retaining their exclusivity.
Thanks for clarifying that. And actually, it does seem that there are some potential lessons learned there in terms of ensuring that the tribes, as you said, under the Federal Indian Gaming Regulatory Act, remain the primary beneficiaries of tribal gaming, and yet having the involvement of professional sports franchises. I'm sure that others will be looking at this as well. So we can circle back to that and talk about more lessons learned, but let's turn over to Kevin now. And as one example of events or jurisdictions with which you're familiar, I know you're familiar with events in the state of North Carolina, for instance, and since this is relatively hot off the presses in the last month or so, we're trying to focus on issues that are coming to the fore now. Kevin, would you like to talk a little bit about relevant dimensions of the state's recently approved compact with the Eastern Band of Cherokee Indians? And or, of course, take it in whatever direction you wish to talk about a particular jurisdiction.
Well, thank you, Steve, and thanks to Catherine and Heidi for joining us, and of course the IMGL for setting this up. I do want to talk a little bit about the North Carolina market with the disclaimer up front. Unlike Heidi, I had nothing to do with the negotiation or direct involvement with the compact between the state and the Eastern Band, and now, which was approved in early March. And now we have a second compact out of North Carolina approved in the last 2 weeks with the Catawba Nation. Both compacts are essentially identical and mirror each other, particularly in respect to sports wagering. The reason I wanted to highlight that is until Heidi's compacts that will be submitted, I think she told us off camera later this week, are approved, these are probably the two most recent compacts approved involving sports wagering, and it gives you an idea of what is happening on the ground. In North Carolina, as Catherine mentioned, they had authorized games, compacts. So in order to get sports wagering at a tribal casino, that meant they actually had to amend their existing compact in the case of the Eastern Band, or a new compact with that included in the case of the Catawba Nation. The compact ended up doing very specifically a couple of items you talked about, Steve, which is one, yes, we're going to approve sports wagering to be conducted at the tribal casino of either the band or the nation, but they put specific limits on it. And this gets into, and we'll talk, I think, picked up, what's the offering channel of sports wagering? And in this, the one offering channel that they've permitted under the compact is you can have a patron come into your tribal casino, place a sports wagering bet at the casino, and then that's permitted under the compact. But you can't have mobile devices or even certainly mobile access to the sports wagering. That was part of the negotiated terms of both the North Carolina compact. So what I call is, that's the physical patron locale rule. You'll see it throughout not only Class 3, but Class 2 gaming, and we'll talk about that. And remind me to get back to, since I just watched a special on Einstein's quantum entanglement theory, I want to talk about why that comes into play here. Unlike perhaps the Arizona compacts and others, the North Carolina compacts, although they authorized sports wagering, a particular offering channel, as I say, the revenue share did not change, but there was the traditional regulatory cost was reimbursed to the state, $191,000 of expected added staffing and time and effort to regulate this from the state side, which is interesting because in the compact, I think it raises the issue is who's going to regulate this, how, under what standards, regardless of whether this is a new brand of wagering. And in the North Carolina compacts, they talk about the regulations applicable to this new tribal sports wagering, Class 3 game, shall be in accordance with federal regulations, including but not limited to applicable regulations and guidelines of the National Indian Gaming Commission. Well, and it's a lot, and I'll just say that's half of it, and then they also say in Appendix A. Let me talk about the first half of the regulations of the National Indian Gaming Commission. For sports wagering, there are none. There are generally still in the books Class 3 minimal internal control standards, but under a court case, I guess approximately 13, 14 years ago now, those were invalidated as acts of the National Indian Gaming Commission. They're still on the books, and in some cases, through compact or otherwise, tribes have adopted those minimal internal control standards. So one could say that's what this is trying to reference, although I don't know if that's exactly what the compact has in mind. Although they reference on Appendix A, where they lay out in multiple pages exactly how sports wagering will be regulated and by who. And again, in that context, they talk about the regulation, the tribe's regulation of sports and horse wagering will again be conducted at a minimum with generally accepted accounting principles and industry standards and practices, and must satisfy as a minimum the National Indian Gaming Commission's Class 3 minimal internal control standards. It could be argued that since those Class 3 minimal control standards are no longer effective, is that meant to be that you'll adopt them themselves, the tribe? So those are the kind of issues that are going to have to be worked out, both at the tribal regulatory level. How's the tribe itself going to implement that from their tribal regulatory? And then are they going to have an issue with the state regulators as to arguing over, is this what the compact meant? And those are the kind of issues that can arise in any compact negotiations. And that's what we have presently on the two most current compacts adopted and approved by the federal government in relationship to the new tribal sports betting market.
Well, thanks, Kevin. That's a great overview of case studies that are developing there. And I will do my best to make sure that we can sneak in a brief physics and relativity and quantum theory lesson in just a moment. But prior to that, one of the core issues I think that you raised toward the end of that overview was the general question that our viewers might be interested in as to how tribal sports betting operations will be or are being regulated. And so we want to pull out some possible issues there or lessons to be learned, and you started us down that path. To Catherine and to Heidi, so would the two of you, either or the two of you, like to comment a little bit on regulatory questions related to sports betting operations?
Well, let me jump in generally and then turn it over to Heidi for more practical insights. So as Kevin mentioned a while ago, there was a case, the CRIT case it's often referred to, the Colorado River Indian Tribes case, which held that the NIGC did not have authority to issue regulations about the operation of Class 3 gaming. As Kevin indicated, though, the NIGC had put a lot of work into formulating minimum internal control standards for Class 3 gaming. Those remain available as guidance. So if the NIGC doesn't regulate Class 3 gaming operations, then that must occur in the compact. And so some compacts call for very hands-on state regulation with a state presence even at the tribal casinos. Other compacts are at the complete other end, where the state might do an annual audit, but otherwise the regulation is left to the tribe. And then, of course, there are some states that fall somewhere in the middle. So generally speaking, for sports books, there too, we would expect that the compact would address whether the state or the tribe is going to have the primary regulatory responsibility for the sports book. And as both Kevin and Heidi referenced, the compact might also require the tribe to pay for any state regulatory role for their sports book.
Great overview. And Heidi, do you have anything you'd like to comment on in terms of those regulatory frameworks?
I can comment from the very recent experience here in Arizona. Our regulatory structure is not going to change with these compact amendments. The compacts have always provided a joint regulatory scheme between both the tribal gaming regulators and the Arizona Department of Gaming. So that is not going to change. The tribes will still have regulatory authority over their tribal casinos in terms of licensing, including the sports book vendors or businesses or whoever is involved with the sports book. So the tribes will still be involved with licensing those entities and individuals, and the state will also retain its ability to issue a what's called a certification to the vendors that are doing business with the tribal casinos, including the sportsbook vendors. So that is not going to change because sports betting is viewed to be a Class 3 game, and therefore it does fall within the compact structure. From the National and Gaming Commission perspective in terms of regulation, the one point I would make for any of those viewing this who are interested or looking to enter into business agreements with any of the tribes for their sportsbook operations, they need to keep in mind that even though the National and Gaming Commission does not technically license those operators, to the extent that their agreement is viewed as a management agreement, they would have to go through the National and Gaming Commission review process. But I think in most cases, those agreements can be structured so that they aren't management agreements, and therefore the agreements simply would need to be reviewed by the National and Gaming Commission and have a declination letter issued to assure that, at least from the National and Gaming Commission's perspective, they're declining to take jurisdiction over that agreement. So there is an overlay of the National and Gaming Commission for these sportsbook operations, as well as state and tribal regulations. So it's a lot of regulation that anybody entering into this area really needs to be aware of, that there's a lot of regulations that they need to comply with at different levels.
That's terrific, Heidi, because it also takes us toward the path that we're heading. We're close to the end on, which is wanting to provide our viewers not just with a sense of what's going on right now and some of the issues, but some very practical tips and takeaways. So that's an important one around thinking about management agreements, contracts, and the NIGC role there, and the idea of seeking or acquiring a declination letter. We'll come back to practical tips and takeaways in just a moment. Kevin, is there anything you'd like to add on this core issue of how sports wagering would be regulated? Anything that we haven't hit thus far that you think is key there?
I think we've covered a lot of the good ground of the issue itself. The one I would point out is, for example, Michigan has a new law, a state law that allows sports wagering. And I know that Dave Villapano, the executive director of the Pokagon Gaming Commission, who's a good colleague of ours, who might be commenting on this on another channel, on another way here. He couldn't join us today. But in relation to that new law, the Tribal Gaming Commission had to adopt its own new chapter. So that's a good resource for people to go to. It's Chapter 13, Sports Wagering. It talks about how it's facilitated at the tribal gaming operation, how the Gaming Commission will regulate that. It's a good hands-on template for those interested in understanding what's the best way to regulate this new form of tribal sports wagering.
That's great. That's really informative. And thanks for pointing to Dave and that particular resource. Let's do just two final things together as a part of our conversation. Let's come back to the issue of mobile that Kevin in particular raised, and hear from our panelists on some of the potential issues there. That's maybe a chance for you, Kevin, to sneak in our physics lesson. And then after that, we'll leave just a moment or two for the practical tips or takeaways, anything that our panelists would suggest along the lines of what Heidi's already done. So let's turn to mobile for just a moment. So obviously, we all know that COVID has changed many aspects of how we live, we work, we play, how we have these kinds of conferences and conversations together, all of which, but particularly the play part, are having a massive impact on the gaming and hospitality industry and the casino industry as well. So with so many of us spending so much more time at home, it seems very plausible that both iGaming and mobile wagering are prime territory and set to really explode in terms of the market potential there. So that does give rise to that important question of how or where mobile wagering fits within the general sports betting framework and the general tribal gaming frameworks that we've been discussing. Just briefly from each of our panelists, I'd ask a couple of questions. You can pick and choose. One is how receptive we think that tribes are in particular, but tribes and states together are to mobile wagering. And then what are some of the compact issues that we might expect there? Would someone like to jump in on that one?
I'll just jump in quick. Arizona's legislation does permit mobile wagering. But it simply has one line saying that it's permitted. So the hows and wheres and the details and all that is going to have to be ironed out, but it is going to be permitted in Arizona.
And there's actually, in sports wagering, as Heidi mentioned in the Arizona Compact, it's permitted. For way of background for the listeners, right now as we speak, there's only one tribal gaming operation, the Southern Utes, who are doing mobile gaming intrastate in Colorado. It means they'll take a wager from anywhere to their tribal gaming facility from anyone physically located within the state of Colorado. And that raises a whole host of issues that aren't necessarily tied directly to sports wagering, but to IGRA gaming generally. And because it's always been tied to, it has to be any gaming activity of the tribe has to be conducted on Indian lands, which is an issue. That phrase, that term within the act has not been definitively defined or applied or implemented generally over the last 30 years. I would point out that our good friends at Gambling Compliance in one of their recent reports did talk about the issue going forward for tribal sports wagering. And I'll just say this: will the launch of online betting and iGaming in Michigan under state regulation for tribes prove a successful model? Or will tribes seek to follow Colorado's Southern Utes by offering mobile wagering beyond their lands under IGRA? And that's where I finally get to talk about quantum entanglement. Because if all the activity of the gaming activity has to be conducted in Indian lands, what has to be decided is generally, as an industry, are we going to view that as where the servers and are located and where the action is of the actual gaming activity? Or is it going to be where the patron, quote, initiates the bet if they're located off reservation? Initiated is an interesting word For example, it is in the North Carolina Compact talks about it has to be initiated by the patron at the casino. But initiated is a phrase that comes from the Unlawful Internet Gambling Enforcement Act. It has nothing to do with IGRA, but it's a concept as, is the industry going to adopt a server locale rule or a patron locale rule? And that's where the entanglement comes, because if the action of the patron is entangled with the action of the server, does that make all that action gaming activity conducted on Indian lands? Or is there some sort of split? It's somewhere along that entanglement line between the two quantums, patron and server, that legally is going to be defined. The answer is unclear. I mean, obviously there's the Desert Rose case that I was involved with many others in the Ninth Circuit that talked about it for purposes of the UIGA, but not of IGRA. So that's going to be the most interesting aspect of mobile sports, tribal sports wagering to me, is how that will work out. Because if that gets worked out in a certain way, it won't just affect tribal sports wagering. It'll affect all Class 3 mobile wagering and all Class 2 mobile wagering under IGRA. And that will, and as you pointed out, Steve, our world has changed drastically in the last 15, 16 months. We are sitting here on a video screen, not together, completely communicating and conducting our businesses just as if we were in person. And that's going to be a concept that's going to have big implications for Indian gaming, not only with tribal sports wagering, but generally. And I'm interested to see how that works out on a practical level.
Absolutely. And again, it is important to recognize the ways in which all of how we live, work, and play has changed and will continue to change. Change is an essential element of how we think about casino operations and hospitality operations going forward, for sure. With mobile as a key part of that, Catherine, did you have anything you wanted to add, considerations from your perspective?
Sure, absolutely. So as Heidi and Kevin have highlighted, these are issues that often come up in the compact negotiations, and yet they don't necessarily have clear legal answers. So practically speaking, in terms of mobile wagering, I think that tribes are on their safest ground when they have the support of the state and it's evidenced through the tribal state compact. But that's not to say that the answers are clear under IGRA, because as Kevin indicated, Indian gaming under IGRA takes place on Indian lands. And so far, the NIGC has taken the position that any gaming conducted by a tribe on Indian lands is governed by IGRA, and any gaming conducted by a tribe off of Indian lands is subject to state law. So there is at least the potential with mobile wagering that we might see a mix of IGRA's applications and state law's applications. And then for sports betting in particular, we have the additional wrinkle of the Federal Wire Act, which applies to interstate communications with relation to sports wagering. And that too does not have a clear answer about its applicability. And importantly, the Wire Act is not enforced by the NIGC. Instead, it's enforced by the Federal Department of Justice. So we have another regulatory agency that would need to weigh in terms of the applicability of the Wire Act to mobile wagering by tribal sports books, even if that's completely limited to Indian lands, or even more problematically, if it is allowed within the boundaries of the state.
Yeah, Steve, I want to follow up on that. That's a great point, Catherine. We've talked about that on prior panels, because this is my thought for tribal regulators, tribal leaders, tribal gaming operators. In regards to the Wire Act, even if you have an intrastate operation, and I'm just going to pick Michigan out, the question is for the Wire Act and the Department of Justice's enforcement of it, there is no case decision, I think we've talked about before, that specifically says that the tribe and its jurisdiction will not be treated the same as a state under the Wire Act. If that's the case, then the fact that there is a wire communication going from a patron located off reservation in Michigan into the tribal casino server on reservation would be an interstate commerce action. And do the tribes really want to, which goes counter, I mean, that's something that the tribes have always worked hard many decades to say that our jurisdiction is co-equal to a state. But do they want to weaken that argument by saying, for purposes of sports betting, mobile sports betting within a state, we don't want the Wire Act to apply? I think you get yourselves all tied up, another entanglement, if you will, with that issue. And that's going to be thought long and hard about whether you want to operate under those conditions.
Well, before we do turn to our final part, which is the tips and takeaways, Heidi, I'd just invite if you had anything additional you wanted to say on those particular kinds of issues, the Wire Act, et cetera, feel free. And otherwise, we'll head to our tips and takeaways.
No, I think Catherine and Kevin covered it very nicely. And other than it, they're challenging, very challenging jurisdictional issues that you need good lawyers involved.
And that might be one of our tips and takeaways, is the importance of expertise in navigating this kind of terrain. And it's really interesting listening to all of you and thinking about that markets often thrive best when there's clarity around regulatory frameworks and regulatory issues. And it sounds like there are a number of areas in which there's yet to be clarity. On the other hand, in those kinds of gray areas and spaces, there's also opportunity as well. Well, let's think about those tips and takeaways. We've heard a number of them from each of you already, but as we draw our panel to a close and our time together to a close, I want to give each of you a chance to address a question something like this. It's certainly a situation that's probably happened to Heidi and to Kevin. Catherine could comment on it as well. Suppose a colleague of some stripe stops by your office today, that would be virtually, presumably, and they say that they have a prospective client in the area of sports wagering, and specifically in with the possibility of tribal sports wagering, and are looking at the intersections there with state law and policy, but they don't know much about it. So what is a practical tip that you would give someone who comes to you under that situation, and as Heidi said at the beginning of our panel, might be interested in entering this area or entering into it in relation to a specific issue in their jurisdiction? Heidi, could we start with you?
Sure. My first words of wisdom is always do your homework, do your due diligence, know the lay of the land, know what the applicable laws are going to be, and know who your business partner is going to be. And you do your homework right, and it will lead to a very good business relationship. So that's pretty basic, but do your homework, do your due diligence, hire a good attorney.
Certainly true, it seems, in navigating the complexities of this area. That's terrific. Kevin, did you have a thought on a tip?
I would second what Heidi just said last, hire a good attorney. But if anyone would approach me, I always say, let's start at the beginning, a very, very good place to begin. What is it that you're trying to accomplish economically? And then we can talk about structures and formats that we might be able to get to the place you want to go and see if it's worthwhile. And to do that, we have to look at the very beginning. We have to start with IGRA, the compacts, tribal gaming regulations, Wire Act, UIGA. We have to take a holistic approach to find out what kind of since we're talking about tribal sports wagering, are we talking about retail on reservation? Are we talking about retail on reservation plus mobile on reservation? Or are we talking about a third? Are we talking about retail, mobile online devices anywhere on the reservation plus remote access from anywhere within a state? Then I guess there's a fourth. Are you talking about retail on reservation, retail mobile on reservation, retail remote access within the state, or maybe not within the state, but internationally, that you only take international patrons? How would that be applied? So those are the kind of things I'd start asking questions and find out what structure they're looking at.
Great. So thinking about first principles and first sources and first goals, that makes a lot of sense. Catherine, from your perspective?
So I will chime into with this is an area where you need an attorney who's experienced in these areas. So gambling law is a particular area of expertise. Federal Indian law is a particular area of expertise. When you combine those two, you have a lot of need for someone who's very aware of the possible issues. And then in particular with sports wagering, I'd layer on that this is a relatively new area because we've only recently had the go-ahead from the Supreme Court striking down PASPA, but also because there's such strong interest in sports wagering, we're seeing some really innovative approaches to tribal sports books, like those in Michigan. And so that pulls in state law in perhaps some unexpected ways. So navigating what exactly this particular tribal sports book looks like and what laws apply to it is not a one size fits all, and very much calls out for hands-on expertise.
Yeah, it really strikes me that, as many of us have heard, that there's a tremendous potential upside to the legalized sports wagering market here in the United States. And related to that, a tremendous potential upside for many tribes. Of course, there is a great deal of variation in terms of how tribes can approach it, the size, the extent of the toe that they might want to dip into the market, from a sports bar to a full-on sports book. And so with that tremendous upside, there's also a lot of chatter these days that we hear about the size and scope of that potential market. It's very exciting, it's very dynamic, it's very new. And if you pair that up with the things that are in the news all the time, like meme stocks and NFTs, and the temptation for quick money, a quick buck, is always out there. But for tribes and their partners, this is in part what I'm hearing all about making decisions in an informed way with expertise, data, and thinking about your tailored market and what you're trying to accomplish when you enter into this. And so in a lot of ways, this is about the risk-reward trade-off, and there's tremendous potential upside. And what I'm hearing is that management of these kind of issues is a part of risk management as well. So what a terrific conversation that we've had. We all want to thank Catherine and Heidi and Kevin, also to all three of them for helping to organize and put this panel together. And again, our thanks to IMGL and ICE 365 for this opportunity to get together. By the way, I just want to note on behalf of all of us that you'll find some biographical information about us on the bookends to this panel. And you can always contact any one of us or all of us. We're happy to assist and answer questions along the way. With that, thank you again to each of our panelists. Catherine, thank you. Heidi, thank you. And Kevin, thank you.
Steve.
And to all, yes, have a wonderful day, and we look forward to hearing from any of you in the future. Take care.
Good seeing you. Thanks.